I was standing in my kitchen on a Saturday morning in March when I saw her marching across my property like she owned the place. The woman had blonde highlights that screamed expensive salon, oversized sunglasses perched on her head, and a clipboard clutched against her chest like a shield. I knew exactly who she was before she even knocked on my door. Patricia Winters, the president of the Meadowbrook Estates Homeowners Association, and based on the tight expression on her face, she was not here for a friendly chat. I opened the door before she could assault it with her knuckles. "Can I help you, Mr. Kenneth Edwards?" She looked down at her clipboard, then back up at me with narrowed eyes. "That's me. I'm Patricia Winters, HOA president. I need to discuss a serious violation on your property." She gestured vaguely toward my barn without actually looking at it. I leaned against the door frame, crossing my arms. What violation would that be? That structure. She pointed now, her manicured nail aimed at my barn like it was an accusation. "It's not approved by the HOA Architectural Committee. It violates our community standards, and frankly, it's an eyesore that's bringing down property values." I had to laugh. I actually couldn't help it. The sound came out more bitter than amused. "That barn has been standing on this property since 1947. Patricia's expression didn't change. "Be that as it may, it doesn't comply with current HOA regulations. You have 30 days to remove it, or we'll be forced to fine you $500 per day until you do." You want me to tear down a barn that's been here for almost 80 years? The architectural guidelines are very clear. No outbuildings without prior approval, no structures that don't match the aesthetic of the community. She pulled a packet of papers from her clipboard and thrust them at me. "This is your official notice. You can appeal at the next HOA meeting if you wish, but I doubt it will change anything. The rules are the rules." I took the papers, scanning the first page. Sure enough, there was a detailed violation notice, complete with photos of my barn taken from different angles, a list of supposed infractions, and a timeline for compliance. "This is ridiculous." "This is community living, Mr. Edwards. When you bought property in Meadowbrook Estates, you agreed to abide by our covenants and restrictions." Patricia adjusted her sunglasses on her head, a gesture that somehow managed to be condescending. "I suggest you contact a demolition company soon. 30 days goes by faster than you think." She turned on her heel and walked away, her expensive athletic shoes crunching on my gravel driveway. I watched her climb into a white Lexus SUV and drive off, still processing what had just happened. The barn stood about 200 feet from my house, a solid structure of weathered wood and stone foundation that had survived decades of Nebraska winters. My grandfather built it with his own hands after returning from World War II. He'd settled on this land when it was still farmland, acres of corn and wheat stretching toward the horizon. The barn had housed livestock, stored equipment, and served as the heart of a working farm. When my grandfather died, my father inherited the property but moved to Omaha for work. He'd kept the land, though, all 40 acres, and when I was ready to build a life for myself, he'd given me 5 of those acres, including the barn. That was 12 years ago, long before this area became desirable, long before developers started carving up farmland into subdivisions with names like Meadowbrook Estates. I'd built my house 7 years ago, a modest ranch-style home that I'd designed myself. The barn had always been part of the package, a piece of family history I had no intention of erasing. I used it as a workshop, a place to restore vintage motorcycles and work on projects away from the house. It was my space, my sanctuary. And now some HOA president with too much time on her hands wanted me to tear it down. I went back inside and spread the papers across my kitchen table. The violation notice was thorough. I'd give them that. They'd cited specific sections of the HOA covenants, included measurements and descriptions, even had a brief environmental assessment claiming the barn was deteriorating and posed a safety risk. None of it was true. The barn was solid. I'd reinforced the foundation 2 years ago, replaced portions of the roof and maintained it carefully. I pulled out my phone and called my father. He answered on the third ring, his voice gruff. "Kyle, what's going on? Dad, do you remember when this property became part of an HOA? HOA. What are you talking about?" I explained the situation, reading portions of the violation notice aloud. My father was silent for a long moment. "Kyle, that barn predates any HOA by decades. When I gave you that land, there was no homeowners association. That all came later, when the developers bought up Johnson's property next door and started building those cookie-cutter houses." "When exactly did the HOA form? Let me think. You built your house in 2012, right? The development started maybe 2013 or 2014, so the HOA probably formed around then. And they somehow think they can make me tear down a barn that existed long before they did. Apparently they do." My father's voice hardened. "Don't let them push you around, son. That barn is your heritage. Your grandfather would roll over in his grave if he knew someone wanted to destroy what he built." After hanging up, I did what any reasonable person in the 21st century would do. I started researching. I pulled up property records online, dug through the county assessor's website, and searched for information about when the Meadowbrook Estates HOA was officially established. The documents confirmed what my father said. The HOA was incorporated in 2014, a full 2 years after I'd built my house. The development had started on the adjacent property, and as it grew, the HOA's boundaries expanded. Somehow, through some legal maneuvering I didn't fully understand, my property had been folded into the HOA's jurisdiction, but the barn had been there since 1947. There was no question about that. I had photographs, property records, even my grandfather's original building permits from Lancaster County. The barn had existed for 67 years before the HOA was even a concept. I spent the rest of the weekend gathering documentation. I found old photographs of my grandfather standing in front of the newly completed barn, my grandmother beside him, both smiling despite the hard years they'd faced. I located the original property deed, the building permits, tax records that listed the barn as an existing structure decade after decade. I even found newspaper clippings from 1947 that mentioned my grandfather's return from the war and his plans to start farming. Monday morning, I called a real estate attorney in Lincoln. Her name was Francine Oliver, and she specialized in property disputes. Her receptionist scheduled me for an appointment that afternoon. Francine's office was in a historic building downtown, the kind of place with high ceilings and original woodwork. She was in her 50s, with short dark hair and sharp eyes that assessed me as I walked in. "Mr. Edwards, tell me what's going on." I laid out the entire situation, showing her the violation notice, the photographs, the property records. She listened without interrupting, making occasional notes on a legal pad. When I finished, she leaned back in her chair. "This is interesting. The HOA is claiming jurisdiction over a structure that predates their existence by several decades. Can they do that? That's the question, isn't it?" She tapped her pen against the legal pad. "Generally speaking, when property becomes subject to HOA covenants, there are grandfather clauses for existing structures. The barn was there before you joined the HOA, before the HOA even existed in any meaningful way. I didn't really join the HOA. They just sort of absorbed my property when the development expanded." Francine nodded. "That happens. Developers often include adjacent properties in their HOA boundaries, sometimes without the owners fully understanding what they're agreeing to. When did you receive your first communication from the Meadowbrook Estates HOA? I had to think about it. Maybe 3 years ago. They sent a welcome packet, explained the dues, the rules. It seemed harmless at the time. The dues weren't that much, and most of the rules were about keeping yards maintained, not parking RVs in driveways, that kind of thing. Did you sign anything acknowledging membership? I paid the dues. I probably signed some form when I paid. You have copies of those documents? I shook my head. I probably just threw them away after paying online. Francine made more notes. Here's what I think. You have a strong case that the barn is a pre-existing non-conforming structure. It predates the HOA. It predates any covenants or restrictions that might apply to your property, and you have extensive documentation proving its existence. However, the HOA isn't going to back down easily. They've issued an official violation notice, which means they're serious about enforcement. What do I do? First, you file an appeal with the HOA. That's your right under their bylaws. Request a hearing before the board. Present your evidence. Give them a chance to back down gracefully. She paused, meeting my eyes. They won't, most likely. These HOA boards tend to dig in once they've taken a position, but you need to exhaust the internal remedies first. And then we go to court. We file for declaratory judgment that the barn is a lawfully existing structure not subject to current HOA restrictions. We'll also move for an injunction preventing them from fining you while the case is pending. How much is this going to cost me? Francine quoted her retainer and hourly rate. It was substantial but not impossible. However, if we win, there's a good chance the court will order the HOA to pay your attorney's fees, especially if they're acting unreasonably, which I believe they are. I hired her on the spot. The next 2 weeks were a blur of paperwork and preparation. Francine helped me draft a detailed appeal letter to the HOA board, complete with supporting documentation. We sent it certified mail, ensuring they couldn't claim they never received it. The appeal requested a hearing at the next board meeting, which was scheduled for early April. In the meantime, Patricia Winters wasn't giving up. She drove by my property at least once a day, sometimes slowing down to stare at the barn like her disapproval alone could make it crumble. Twice more she came to my door, each time with new complaints. "The paint is peeling," she said on the first visit. "It's a 77-year-old barn. It's supposed to look weathered. It's a safety hazard. What if it collapses?" "It's not going to collapse. The structure is sound." On her second visit, she brought a man with her, introducing him as Dennis Fletcher, the HOA's attorney. He was younger than I expected, probably mid-30s, with slicked back hair and an expensive suit. "Mr. Edwards, I'm advising you to comply with the violation notice voluntarily," Dennis said, his tone suggesting he was doing me a favor. "If this goes to litigation, the costs will be significant. The HOA has deep pockets. We can litigate for years if necessary." Is that a threat? It's a reality. HOAs exist to maintain property values and community standards. Your barn violates both. We have an obligation to enforce our covenants. The barn predates your covenants. That's a matter of interpretation. Dennis handed me his business card. Think about what's best for everyone involved. Sometimes the smart move is to accept reality and move forward. They left, and I immediately called Francine to tell her about the visit. "They're trying to intimidate you," she said. "Don't let them. We have a strong case. Just keep documenting everything. If they come to your property again, take notes on what they say, what time they arrive, all of it." The HOA board meeting was held on a Thursday evening in the clubhouse of the Meadowbrook Estates development. The clubhouse was exactly what you'd expect. Bland corporate architecture, beige walls, generic landscape paintings. About 20 people sat in folding chairs facing a table where the board members presided. Patricia sat in the center, flanked by 4 other board members I didn't recognize. Dennis Fletcher sat to the side, laptop open, looking bored. Francine and I took seats in the front row. I dressed in slacks and a button-down shirt, wanting to look respectful but not desperate. Francine wore a sharp blazer and carried a briefcase full of documents. The meeting started with routine business, approving minutes, discussing landscaping contracts for the common areas, reviewing the budget. It was mind-numbing, and I could see why most homeowners didn't bother attending these things. After 45 minutes, Patricia finally called my name. We'll now hear the appeal from Kenneth Edwards regarding the violation notice for an unapproved structure at 14,287 Heritage Lane. I stood, and Francine joined me at the front of the room. She'd prepared a presentation, complete with a timeline showing the barn's construction in 1947, photographs from different eras, property records, everything we'd gathered. "Members of the board," Francine began, her voice calm and professional. "We're here today because Mr. Edwards received a violation notice demanding he remove a barn that has stood on his property for 77 years. This barn was built by his grandfather in 1947, 2 years after returning from World War II. It predates this HOA by 67 years. She walked through the evidence methodically, showing the photographs, explaining the property history. This is a clear case of a pre-existing non-conforming structure. Under Nebraska law, such structures are generally grandfathered in when new regulations are imposed. The barn was there before any of your covenants existed. It was there before this development existed. It cannot be subject to retroactive removal." Patricia listened with her arms crossed, her expression unchanging. When Francine finished, Patricia looked at Dennis. "Mr. Fletcher, your response?" Dennis stood, barely glancing at his laptop. "The HOA's position is straightforward. When Mr. Edwards's property became subject to our covenants, all structures on that property became subject to our architectural review. The barn is not compliant. It's that simple. The age of the structure is irrelevant." "It's completely relevant," Francine interjected. "You can't impose new restrictions on structures that existed before your authority existed." "We can enforce our current standards," Dennis countered. "Mr. Edwards is a member of this HOA. He pays dues. He receives the benefits of membership. He also has obligations, including compliance with architectural guidelines." The board members whispered among themselves. Patricia called for a vote on the appeal. It took less than a minute. All 5 board members voted to deny the appeal and uphold the violation notice. "The violation stands," Patricia announced. "You have until May 15th to remove the barn or face daily fines of $500. Walking out of that meeting, I felt anger bubbling up. They didn't even consider the evidence. "They never intended to," Francine said. "This was a formality. Now we go to court." She filed the lawsuit the next week. The case was styled Edwards v. Meadowbrook Estates Homeowners Association, and we were seeking declaratory judgment and injunctive relief. Francine drafted a comprehensive complaint outlining our position, attaching all our evidence as exhibits. The HOA responded with a motion to dismiss, arguing that we hadn't exhausted all internal remedies. The judge denied their motion, noting that we'd already appealed to the board and been rejected. The case would proceed. Discovery began. a tedious process of exchanging documents and taking depositions. Dennis Fletcher threw every obstacle he could in our path, objecting to document requests, scheduling depositions at inconvenient times, generally making the process as painful as possible. "He's running up the bill," Francine explained. "The HOA is paying him hourly and he knows it. He's also trying to frustrate you into giving up. That's not happening. Good, because we're going to win this." During the discovery process, we uncovered some interesting facts. The HOA's incorporation documents from 2014 included a section about pre-existing structures. It stated that any structure lawfully existing prior to the HOA's formation would be considered conforming unless it posed a health or safety hazard. It was exactly the grandfather clause Francine had mentioned. "They have this provision in their own documents," I said, reading the language. "Why are they ignoring it?" "Because Patricia Winters doesn't like your barn," Francine said bluntly. "This isn't about rules or property values. It's personal. Maybe she doesn't like you, maybe she doesn't like the way the barn looks, maybe she's just on a power trip. But this is about her ego, not about legitimate HOA concerns." We also deposed Patricia. She sat in a conference room at Francine's office, Dennis beside her, and answered questions with barely concealed hostility. "Miss Winters, when did you first become aware of Mr. Edwards's barn?" Francine asked. "When I became HOA president last year." "And what was your initial reaction?" "I thought it was an eyesore. It doesn't fit with the aesthetic of our community." "Did you review any documents regarding whether the barn was a pre-existing structure?" "I reviewed the architectural guidelines. The barn doesn't comply." "But did you review the HOA's incorporation documents? Specifically, the provision regarding pre-existing structures?" Patricia hesitated. "I'm aware of that provision. And doesn't that provision state that lawfully existing structures prior to the HOA's formation are considered conforming, only if they don't pose safety hazards?" "Do you have any evidence that Mr. Edwards's barn poses a safety hazard? It's old. Old structures are inherently risky." "Have you had it inspected by a structural engineer?" "No." "Have you had it inspected by anyone with expertise in building safety?" "No." "So you have no actual evidence of a safety hazard, do you?" Dennis interrupted. Asked and answered. Francine pressed on. "Miss Winters, isn't it true that you simply don't like the appearance of the barn and you're using your position as HOA president to try to force its removal?" "I'm enforcing our community standards," Patricia said, her voice rising. "That's my job." The deposition went on for hours, and by the end, it was clear that Patricia had no legitimate basis for the violation notice. She just didn't like the barn. We also hired a structural engineer to inspect the barn and provide a report. He spent an afternoon measuring, photographing, testing the wood and foundation. His report was unequivocal. The barn was structurally sound, posed no safety risk, and with proper maintenance could last another 70 years. May 15th came and went. The HOA started assessing fines, $500 per day, exactly as threatened. By the end of May, they claimed I owed $15,000. Francine filed an emergency motion for an injunction, and the judge granted it, ordering the HOA to cease all fining activity until the case was resolved. "They're going to appeal that," Dennis warned at the hearing. "Let them," the judge said. "The defendant has raised serious questions about the validity of this violation notice. Fining him thousands of dollars while the case is pending would cause irreparable harm." The trial was scheduled for late July. As the date approached, I felt a mixture of anxiety and anticipation. I'd spent thousands on attorneys' fees, invested countless hours in preparation, all to defend a barn that was rightfully mine. But it was about more than the barn. It was about standing up to unreasonable authority, about protecting family heritage, about not letting bullies win. The trial took place in the Lancaster County District Court in Lincoln. Judge Raymond Morrison presided, a man in his 60s with gray hair and a reputation for fairness. The courtroom was smaller than I expected, with wooden benches and flags flanking the judge's bench. Francine presented our case first. She walked the judge through the entire history, showing the photographs of my grandfather, the building permits from 1947, the property records spanning decades. She introduced the structural engineer's report, highlighting the barn's soundness. She pointed to the HOA's own incorporation documents and the grandfather clause for pre-existing structures. "Your Honor, this is as clear-cut a case as you'll ever see," Francine argued. "The barn predates the HOA by 67 years. It's a lawful, safe structure that's been maintained for generations. The HOA has no legitimate basis for demanding its removal. This is an abuse of authority, plain and simple." Dennis Fletcher presented the HOA's case, arguing that the covenants gave the board broad authority to enforce community standards. He claimed the barn was deteriorating, despite our engineer's report to the contrary. He argued that property values in the community were suffering because of the barn's presence, though he offered no evidence to support that claim. "The members of this HOA have invested in their homes with the expectation that certain standards will be maintained," Dennis said. "Mr. Edwards can't simply ignore those standards because he wants to keep an old barn." Judge Morrison asked questions throughout, clearly engaged with the issues. When both sides finished presenting evidence, he called for closing arguments. Francine stood, her voice clear and confident. "Your Honor, the law is unambiguous. Pre-existing non-conforming structures are protected. The barn predates the HOA. It predates the covenants. It predates everything the HOA is trying to enforce against Mr. Edwards. The HOA's own documents acknowledge this principle, yet they're choosing to ignore it. Mr. Edwards has a property right to maintain this barn. It's part of his family history and it's lawful. The HOA's violation notice should be declared void, and they should be ordered to cease all enforcement activity related to the barn." Dennis gave his closing, reiterating the HOA's position, but I could see he was fighting an uphill battle. The evidence was overwhelmingly in our favor. Judge Morrison took less than an hour to reach his decision. When we returned to the courtroom, he had a written order ready. "I've reviewed all the evidence and arguments presented by both sides," Judge Morrison began. "This case turns on a relatively straightforward question. Can the Meadowbrook Estates HOA enforce its architectural covenants against a structure that predates the HOA's existence by more than 60 years? He paused, looking directly at Dennis Fletcher. "The answer is no. Mr. Edwards has presented compelling, thoroughly documented evidence that the barn on his property was constructed in 1947. He has building permits, property records, photographs, and testimony establishing its history. The HOA was not incorporated until 2014. The HOA's own governing documents include a provision protecting pre-existing structures. The barn is clearly such a structure." Patricia sat rigid in her chair, her face reddening. "Furthermore," Judge Morrison continued, "the HOA has presented no credible evidence that the barn poses any safety hazard or otherwise justifies the extreme remedy of forced removal. The structural engineer's report confirms the barn is sound and well maintained. The HOA's claim that it's an eyesore is subjective and insufficient to override Mr. Edwards's property rights." He looked down at his written order. "Therefore, I find in favor of the plaintiff, Kenneth Edwards. The barn is a lawfully existing pre-existing non-conforming structure, not subject to the HOA's current architectural covenants. The violation notice issued by the HOA is void and unenforceable. The HOA is permanently enjoined from taking any enforcement action against Mr. Edwards related to the barn, including the imposition of fines. Relief flooded through me, so intense I almost felt lightheaded. Additionally, Judge Morrison said, I find that the HOA's enforcement action was unreasonable under the circumstances. Mr. Edwards is entitled to recover his attorney's fees and costs. The parties will submit documentation of those fees within 30 days. Francine squeezed my arm. We'd won. Completely. After the judge left the bench, Patricia stormed out of the courtroom without a word. Dennis gathered his papers, his expression neutral, professional detachment masking whatever he actually felt. Outside the courthouse, Francine and I stood on the steps in the summer sunshine. "Congratulations," she said. "That was as decisive a victory as I've ever seen. Thank you for everything. I couldn't have done this without you. You did the hard part. You stood your ground. A lot of people would have just given in, torn down the barn to avoid the hassle. You fought for what was right." I drove home feeling lighter than I had in months. The stress of the lawsuit had been constant, a weight pressing down on everything. Now it was over. The barn was safe. My grandfather's legacy was protected. When I pulled into my driveway, I sat for a moment looking at the barn. The late afternoon sun cast long shadows across the weathered wood. It looked the same as it always had, solid and enduring, a connection to the past. I got out of my truck and walked over to the barn, running my hand along the wood frame. My grandfather had stood here, building this with his own hands, creating something that would last. He'd survived a war, come home and built a life. The barn was a testament to that determination. My phone rang. It was my father. "Kyle, how did it go?" "We won, Dad. The judge said the barn predates the HOA and threw out their case." I heard emotion in my father's voice. "Your grandfather would be proud. I'm proud. I couldn't let them tear it down. It's family." "Damn right it is." Over the next few weeks, life slowly returned to normal. The HOA submitted the attorney's fee documentation, and Judge Morrison ordered them to pay nearly $30,000 to cover my legal costs. It was more than I'd spent, which meant I actually came out ahead financially. Patricia Winters resigned as HOA president 2 weeks after the trial. I heard through neighborhood gossip that the other board members pressured her out, unhappy about the legal fees and the bad publicity. The lawsuit had made the local news, framed as a David versus Goliath story, and the HOA came out looking petty and vindictive. A new HOA president was elected, a man named Robert Chen who seemed more reasonable. He sent me a letter apologizing for the conflict and assuring me the HOA would not pursue any further action regarding the barn. He invited me to join the architectural committee, suggesting my input might help prevent similar situations in the future. I politely declined. I'd had enough of HOA politics. The barn stood, as it always had, a piece of history in a rapidly changing landscape. The Meadowbrook Estates development continued to grow, new houses sprouting up, families moving in. But my 5 acres remained different, a reminder of what the land used to be. I kept using the barn for my motorcycle restoration projects. It was peaceful there, surrounded by tools and parts, the smell of motor oil and metal. Sometimes I'd find myself thinking about my grandfather, wondering what he'd think of the world now, of subdivisions where farms used to be, of HOAs and violation notices. One Saturday in September, About 2 months after the trial, I was in the barn working on a 1972 Triumph Bonneville when I heard a vehicle pull up. I walked outside to find an old pickup truck, much like my own, with a man about my age climbing out. "Can I help you?" I asked. "I hope so." "My name's Jack Peterson. I live over in Eagle, about 20 miles from here. I read about your case in the paper, about the HOA trying to make you tear down your barn." "Yeah, that was me. I'm dealing with something similar. My property got absorbed into an HOA when they built a development nearby. Now they're saying I have to remove my chicken coop. It's been there for 15 years, way before the HOA existed." I felt a familiar anger stirring. "They can't make you do that. They're threatening fines, just like they did to you. I was hoping maybe you could tell me about your attorney, how you fought back." I invited Jack into the barn, and we spent an hour talking. I told him about Francine Oliver, about the evidence we'd gathered, about the pre-existing non-conforming structure argument. I showed him some of the documents I'd kept, explained the legal strategy. "The key is documentation," I said. "Prove your chicken coop was there before the HOA. Get photographs, property records, whatever you can find. Then get a good attorney who understands property law. Did you ever think about just giving in, avoiding the fight?" "Every day," I admitted. "It would have been easier, but it was the principle. They had no right to make me tear down something my grandfather built. Some things are worth fighting for." Jack left with Francine's contact information and a renewed determination. I heard from him a few months later, his case settled before trial. The HOA backed down once they saw his documentation, not wanting another expensive legal battle they'd likely lose. Word spread. Over the next year, I heard from 3 more people dealing with similar HOA disputes. I became an accidental expert on pre-existing structures and HOA overreach. It was strange, becoming known for this, but it felt good to help people stand up to unreasonable authority. The barn became somewhat famous locally. People would drive by slowly, taking pictures, pointing it out as that barn from the news. A local historian contacted me, asking if she could include it in a book about historic agricultural structures in Lancaster County. I agreed, and she spent an afternoon photographing and interviewing me about my grandfather's story. Life continued. Seasons changed. Winter came, and snow covered the barn's roof, accumulating in drifts against the foundation. Spring brought rain and new growth, grass greening up around the property. Summer heat baked the weathered wood. Fall painted the surrounding trees in gold and red. The barn endured through it all as it had for 77 years. I thought about Patricia Winters sometimes, wondered if she'd learned anything from the experience. Probably not. People like her rarely did. They were so convinced of their own righteousness, their own authority, that evidence and reason couldn't penetrate. She'd moved on to other battles, other crusades, someone else's problem now. The Meadowbrook Estates HOA operated more smoothly under new leadership. Robert Chen ran things with a lighter touch, focusing on actual community issues rather than personal vendettas. I paid my dues, attended the occasional meeting, and kept my property maintained. We had a functional, if not warm, relationship. My father visited one weekend in October, driving down from Omaha. We stood together looking at the barn, and I could see emotion on his face. "You know, when I gave you this land, I worried sometimes about what would happen to the barn after I'm gone," he said. "Whether you'd maintain it, whether it would just fade away, but you fought for it, you kept it alive. It's part of who we are, Dad, our history. Your grandfather built it with his hands, but you saved it with your will. That means just as much." We spent the afternoon working together in the barn, father and son, continuing a tradition that stretched back generations. The tools felt familiar in my hands, the rhythm of work comfortable and right. That evening, sitting on my porch with cold beers, my father asked, "Any regrets?" About the fight with the HOA, the money, the stress. I considered the question. The lawsuit had taken months of my life, thousands of dollars, countless hours of anxiety and frustration. It would have been easier to walk away, to let them win. "No regrets," I said. "Some things are worth fighting for. Family, heritage, principle. The barn was all three." "Good. That's the right answer." As darkness fell, I looked out at the barn's silhouette against the night sky. Lights from the development glowed in the distance, modern suburban life humming along. But here, on my 5 acres, the past and present coexisted. The barn stood as a bridge between eras, a reminder that some things endure despite everything trying to erase them. The next morning, after my father drove back to Omaha, I walked out to the barn with my coffee. The air was crisp, autumn asserting itself. I unlocked the door and stepped inside, breathing in the familiar smells of wood and oil. On the wall, I'd hung the framed newspaper article about the trial, alongside the original photographs of my grandfather standing in front of the completed barn in 1947. The similarities between us were striking. Same height, same build, same determined set to the jaw. Different eras, different challenges, same stubborn refusal to back down. I settled in to work on a carburetor rebuild, losing myself in the methodical process. This was why I'd fought so hard, not just for the building itself, but for what it represented. A place to work with my hands. A connection to family. A space that was mine, free from committees and covenants and other people's opinions. The months after the trial taught me something valuable about community and compromise. The new HOA leadership reached out several times, trying to build bridges. Robert Chen invited me to a neighborhood barbecue, which I attended. People were curious about me, about the barn, about the lawsuit. Most were friendly, sympathetic even. "I'm glad you won," one neighbor told me, a woman named Sarah who lived 3 streets over in the development. "The HOA needed to be reminded they don't own us. They work for us." Others agreed. The lawsuit had sparked conversations in the neighborhood about HOA authority, about where the line was between reasonable community standards and overreach. Several homeowners had their own grievances, their own stories of petty enforcement and unreasonable demands. "They fined me $200 because my garage door was open past 8 p.m., one man said. "Said it was unsightly. I was working on my car." "They made me repaint my house because the beige wasn't the right shade of beige," another added. "Cost me $3,000. The stories accumulated, painting a picture of an organization that had lost sight of its purpose. HOAs were supposed to maintain property values and provide common services. Instead, many had become enforcement agencies, generating revenue through fines and flexing authority for its own sake. My case became a rallying point. At the next HOA meeting, several homeowners proposed amendments to the covenants, adding protections against arbitrary enforcement, requiring evidence before violations could be issued, creating an independent appeals process. The measures passed overwhelmingly. Change came slowly, but it came. The HOA became more transparent, more accountable. Board meetings drew bigger crowds. Homeowners paid attention now, engaged in the process instead of abdicating authority to whoever wanted to serve. I'd never intended to become a community activist. I just wanted to keep my barn. But the fight had consequences beyond my property line, rippling outward in ways I hadn't anticipated. Winter arrived with force in December, temperatures dropping below zero, wind howling across the plains. I made sure the barn was secure, checking for gaps where cold could penetrate, ensuring the roof could handle snow loads. The structure held firm as it always had. Christmas came, and I hosted my family for the first time in years. My father drove down from Omaha, bringing my aunt and uncle. We gathered in my house, eating and talking, and after dinner I took them out to the barn. "I added something," I said, flipping on the lights. On the far wall I'd mounted a large wooden plaque with brass letters. It read, "Built 1947 by Harold Edwards. Saved 2020 by Kenneth Edwards. May it stand for generations more." My father stood silent for a long moment, then cleared his throat roughly. "He'd be proud, Kyle, so damn proud." The barn had become more than just a building. It was a statement, a monument to persistence and principle. People in the community knew its story, knew what it represented. It stood as proof that you could fight back against unreasonable authority and win. As the year drew to a close, I found myself reflecting on everything that had happened. The intimidation, the legal battle, the ultimate victory. I'd learned lessons I never expected to learn, about law and property rights, about standing firm when pressure mounted, about the value of good legal counsel, about community and what happens when people stop paying attention to those who govern them. I'd also learned about my own capacity for determination. There were moments during the lawsuit when giving up seemed rational. The stress was immense. The financial cost kept climbing. The uncertainty gnawed at me. But I'd pushed through, refusing to let Patricia Winters and her power trip destroy something precious. New Year's Eve, I stood alone in the barn at midnight, a glass of whiskey in my hand. Outside, fireworks exploded from the development, celebration and noise. Inside the barn, it was quiet, peaceful. "Here's to you, Grandpa," I said aloud, raising my glass toward the photographs on the wall. "Thanks for building something worth fighting for." The barn didn't answer, but I felt connected to my grandfather in that moment, across the decades, across the divide between living and gone. He'd built with his hands. I defended with my will. Together, we'd ensured the barn would endure. January brought new challenges and opportunities. Francine Oliver called with surprising news. A state legislator had read about my case and wanted to introduce a bill protecting pre-existing structures from HOA overreach. Would I be willing to testify before a committee? I agreed without hesitation. In February, I drove to the state capitol in Lincoln and testified before the Judiciary Committee. I told my story, explained the legal battle, made the case for clearer protections in state law. Other homeowners testified too, sharing their own HOA horror stories. The bill passed committee and eventually became law, signed by the governor in April. It required HOAs to respect pre-existing structures and created penalties for unreasonable enforcement actions. My barn had sparked actual legislative change. Life developed a new rhythm. I worked my regular job during the week, a civil engineer for a firm in Lincoln. Evenings and weekends, I spent time in the barn, working on my projects, maintaining the property. I dated occasionally, though nothing serious developed. I was content with my life, with my 5 acres and my barn and my hard-won peace. The years following the trial were quiet ones, in the best possible way. No more HOA drama, no more threats or violation notices. Just normal life, punctuated by the changing seasons and the steady work of maintaining a property. The barn needed a new coat of stain in its second summer after the trial. I spent weekends applying it carefully, preserving the wood for another decade. I replaced some windows, updated the electrical, made small improvements that honored the original structure while ensuring it remained functional. People still drove by sometimes, pointing it out, telling the story to passengers who hadn't heard it. The barn had become a local landmark, symbolic of something larger than itself. I thought about Patricia Winters occasionally, wondering what she'd moved on to, whether she'd learned anything. Probably she was making someone else's life miserable, wielding whatever authority she could grab, convinced she was right and everyone else was wrong. Some people never changed, but I had changed. The fight had made me more aware, more engaged, less willing to accept authority without question. I paid attention to local politics now, to HOA meetings, to the mechanisms that governed community life. I'd learned that apathy was dangerous, that you had to watch those in power or they'd abuse it. The barn stood through it all, weathering storms literal and metaphorical. It had survived 7 decades before I became its defender, and with proper care, it would survive many more after I was gone. On warm summer evenings, I'd sometimes sit in the barn's doorway, watching the sun set over the developing landscape. The world was changing rapidly, farmland becoming suburbs, open space filling with houses. But this little corner remained different, a piece of the past holding firm against the tide of progress. I thought about legacy, about what we leave behind. My grandfather left the barn, a physical monument to his labor and vision. I'd saved it, adding my own chapter to its story. Someday, maybe I'd have children who would inherit it, who would stand in the same doorway and feel connected to ancestors they'd never met. The barn made that connection possible. It was a thread binding past to present to future, a tangible reminder that we're part of something larger than ourselves. Years passed. The barn stood. The HOA functioned more reasonably under continued new leadership. The community evolved, finding balance between standards and freedom, between community and individual rights. My lawsuit had been a catalyst for positive change, forcing conversations that needed to happen. I never regretted the fight. The stress, the cost, the months of uncertainty, all worth it to preserve what mattered. Sometimes you have to stand up, draw a line, say this far and no further. The barn was my line and I'd held it. Looking back from the vantage point of years later, I could see how the experience had shaped me. I was more confident, more willing to advocate for myself and others. I'd learned that systems of authority, even small ones like HOAs, needed checks and challenges. I'd learned that documentation and evidence mattered. I'd learned that good legal counsel was worth every penny. Most importantly, I'd learned that some things were worth fighting for, even when the fight seemed unwinnable. Principle mattered. Heritage mattered. Standing up to bullies mattered. The barn stood as proof of all those lessons, weathered wood and stone foundation holding firm against time and opposition. It was there before I was born. It would be there after I was gone, and that continuity meant everything. I kept the framed court order in my house, Judge Morrison's signature making it official. The barn predated the HOA and was protected from their overreach. Sometimes visitors asked about it, and I'd tell the story, watching their expressions shift from curiosity to outrage to satisfaction as they heard how it ended. Everyone loved an underdog victory story. Everyone appreciated seeing arrogant authority put in its place. The story resonated because it touched on universal themes: fairness, justice, the small guy refusing to be pushed around. The barn became shorthand for those themes, a symbol that you could fight back and win if you had evidence and determination, and a willingness to see things through. As spring arrived once more, bringing new growth and renewal, I stood in the barn surrounded by my tools and projects and the accumulated memories of generations. The structure smelled of wood and history, solid and enduring. My phone buzzed. Another person dealing with HOA overreach, asking for advice. I answered, as I always did, willing to help someone else navigate the same challenges I'd faced. The key is documentation, I told them. Prove your case with evidence they can't dispute. Then find a good attorney and fight back. Don't let them intimidate you into surrendering what's rightfully yours. It was advice I'd give again and again, helping others stand up to unreasonable authority, sharing the lessons I'd learned the hard way. The barn stood behind me as I talked, solid and permanent, a testament to the value of fighting for what mattered. It had weathered 77 years before my battle, and it would weather 77 more, a piece of family history preserved against all odds. And that made everything, the stress, the cost, the months of fighting, completely worth it.